Okay, so last week we spoke about divorce. This week's topic is slightly more uplifting, custody. Kidding, it's not. That's about as funny as I'm going to be, I guess. So, Custody 101. All right, same rules apply as last week. We are not talking about divorce. We are not talking about child support, and we're not talking about how to file for custody on your own. We are talking about custody in Pennsylvania. And I can be more specific about Chester and Montgomery County if you guys are all from those counties. Yes, no? Chester? Okay, so that's good to know. All right, types of custody. We have physical and we have legal. First up, physical custody. Definition: the actual physical possession and control of a child. Essentially, where does the child sleep? Where does the child live? Types of physical custody. Couple different, or I should say 5 or so different arrangements of shared physical custody in Pennsylvania. Shared physical custody. The right of more than one individual to assume physical custody of the child, each having significant periods of physical custodial time with the child. In Pennsylvania, if a party has shared physical custody, it's usually means 50-50, or equal physical custody. So they spend the same amount of overnights with both mom and dad. Primary physical custody is when one individual has the right to assume physical custody for a majority of the time. So in a primary custody arrangement, mom has weekdays and every other weekend, and dad has an overnight and the remaining alternate weekends. Partial physical custody, the right to assume physical custody of the child for less than the majority of the time. So that would be dad in my example that I just gave. He has it for less than 50% of the time. Sole physical custody, the right of one individual to have exclusive physical custody of the child. It is what it sounds like. One parent has the custody 365 nights. Supervised physical custody, custodial time during which an agency or an adult designated by the court or agreed upon by the parties monitors the interaction between the child and the individual with those rights. When mom or dad is exercising his physical custody, someone else must be present. It can be, like it says, someone at the court orders, or it can be someone who the parties agree to. If dad lives with his mom, maybe they can agree that grandmom can be the supervisor. The issue is when you have supervision that is not a family member, is you're usually paying that person, a court-ordered person. They're not doing it for free. So to keep costs down, it always is a good idea to have someone who you can, both parties can agree can be a supervisor. Like I said, a grandparent or a family friend or other family member. All right, legal custody. The right of the right of a party to make major decisions on behalf of the child, including but not limited to medical, religious, and educational decisions. In almost every circumstance, even if a party has primary physical custody or 60% physical custody, the parties are going to share legal custody. It's 50-50. It's not, you have to agree before a decision can be made, okay? And that goes for all the major, like I said, medical, religious, and educational. Educational, private versus public. Medical, to get braces or to not get braces. To have surgery, not to have surgery. Religious, how are we raised, are the kids going to church? The parties have to agree on those decisions. And it's very hard to have it's very, very difficult for one party to have sole legal custody. Here it is, the right of more than one individual versus sole legal, the right of one individual. Sole legal custody is rarely granted in the state. An example, when dad's in jail. That's an extreme, but that's the type of situation you're looking at when you have sole legal custody. All right, in Pennsylvania, most recently, and by most recently I would say 2010, 2011, they changed the law, or they, I guess, modified the law as to how custody is determined, okay? Against the backdrop, any determination of custody in Pennsylvania is determined against the backdrop of the best interest of the child, okay? But you consider all relevant factors, giving weighted consideration to those factors which affect the safety of the child, including the following. So the following list are what you're going to hear they're known as the 16 factors, okay? Judges, if your case ever goes to a custody trial, courts are required to examine the 16 factors when making custody determination, okay? They are literally required to. If they do not do it, then their order, you can appeal. So here they are, okay? Some of these are going to be subjective, some of these are going to be objective, and obviously as we go through them, you'll be able to see which ones are either. Which party is more likely to encourage, permit frequent and continuing contact between the child and another party? You have a custody arrangement, and the one parent has been asking the other parent for more time, or to switch weekends, or for, can I get a couple hours more here than we'd agreed to? And the party who's being asked is saying no all the time. They're never compromising at all, okay? They're just not letting any contact between the other party, okay? That's where factor number one. It's about flexibility, it's about compromise. Number two, the present and past abuse committed by a party or member of the party's household, and whether there's a continued risk of harm to the child or an abused party, in which party can better provide adequate safeguards and supervision of the child. I think abuse is pretty straightforward. I mean, if you're gonna be talking about emotional versus physical, you're obviously, if that's what's a factor that you really think is important in your case, and you're gonna have to have the evidence to back it up. What kind of evidence am I talking about? Maybe you have a PFA against the other spouse. Does that PFA cover the child? Maybe, maybe not. Has that abuse occurred within the child's, has the child witnessed the abuse? There's 16 factors, they all have weight, so just keep in mind that if number two is present, that doesn't make or break your case, okay? The parental duties performed by each party on behalf of the child. When the kids are little, there aren't too many duties that you're feeding your kid, you're dressing your kid, you're taking them to the doctors, you're putting them to bed. As they get older, I feel like the duties sort of increase. There's school, there's sports, who's taking them. I mean, just think, you go, essentially what you're doing is, if I'm your attorney, I'm gonna tell you to take me through your day. Who gets the kid up, who feeds the kid, and go from morning to afternoon, morning to night, essentially. And you'll get a pretty good idea as to who's performing each. And obviously there's going to be exceptions. Sometimes dad's gonna say, well, I take him to the doctor sometime. Okay, well, one time over 10 years, you're not gonna get a whole lot of credit for that, okay? You're gonna have a pretty idea of who does the majority of these things. Unless it's a 50-50, that's very possible. The need for stability and continuity in the child's education, family life, and community life. If you're, this is something that also is a little bit more important when the kid's older. A 1 or a 2-year-old, you don't really have to worry about continuity in the child's education and community life, because they're not going to remember anyway. But if you have a parent who is moving away and now wants to have more custody, you're going to look at that, such as, the disruption, if they're involved in the community, and what kind of, how the move or how a different custody arrangement is perhaps going to interfere with that. Availability of extended family, aunts, uncles, grandparents, and how involved they've been in the child's life, and the extent of the interaction between everyone. We definitely have cases where, grandparents are very involved, or there are other cases where a parent has just no one in the area. It really depends. The child-sibling relationships, this is one of those objective ones. You either have sibling relationships or you don't. The well-reasoned preference of the child based on the child's maturity and judgment. This is not a black letter law, but most judges will not listen to a child's preference until they're 7 years old. 7 years old or older. The older they get, obviously, the more weight a judge will give to a child's preference. Anything younger than 7 o'clock, anything younger than 7 years old, it's sort of hard to believe what they're gonna say. Which party is more likely to maintain a loving, stable, consistent, and nurturing relationship with the child, adequate for the child's emotional needs? This one is, I always lump 9 and 10 sort of together. Which party is more likely to attend to the daily physical, emotional development, educational, special needs of the child? So number 10, the judges will kind of focus on whether the child has special needs or learning disabilities. That's sort of where number 10 is. While number 9, it's pretty. I mean, it's pretty subjective as to how you look at that, right? Like a parent who has been, involved, supportive, emotionally available, is what you're sort of looking at there, and that's really going to be what you testify to. It's going, as far as proof, it's really going to be your testimony.
You didn't touch on number 8.
Oh, I'm sorry. The attempts of a parent to turn the child against the other parent, except in cases of domestic violence where reasonable safety measures are necessary to protect the child from harm. This is basically when you're bad-talking a parent to the child, or you're bad-talking it, or you're doing it in the child's presence, and you are essentially interfering with that child's relation to the extent where that child is now not wanting to go with the other parent. Yep.
The legal process is, in a way, a proxy for what the real world is, and so you're trying to replicate what the real world is, hopefully truthfully. But if there's parties, each party is saying the opposite, and one parent is poisoning the child's mind or has poisoned, how do you prove that in court?
Get a custody evaluation.
A custody evaluation.
Yeah. How do I prove it?
Yeah.
You talk to the child. You're gonna have if you think parental alienation is going involved in one of your cases, you're probably gonna have to have a psychiatrist involved, someone who's going to talk to the child and testify in court.
So they're trained to break through that barrier that maybe the other spouse has created?
Mm-hmm.
I see.
In response to that, I personally, my 2 youngest daughters' mothers, I would hear mother would say, make sure you say this and make sure you say that. It was kind of like coaching.
Yeah, so who heard this?
I heard it, but to answering how would you prove it in court?
If you think it's going on,
But then the child will say, and she would say, if anybody ever asked, just say, no, I thought of this on my own.
So you're right, it's hard to prove. It's hard to prove unless you want to spend the money and the resources to prove it. And even then, it's not a slam dunk.
If it can be proved, how much weight does the court give?
Whatever the judge thinks to give it. It depends who you have as a judge. It depends how persuasive your evidence is. Because remember, we're talking 1 of 16 factors, right? So if the judge is going to give it, depending on the extent of the alienation, I'm calling it alienation, let's just for the purposes. The extent of the alienation can have a little effect or it can have 0 effect, or a lot. Rarely are you going to have someone, this is, to be truthful, if you have primary custody and if you have partial custody and you think that there's parental alienation going on, it's going to be very hard to switch it so that you have primary custody based on parental alienation, because you're essentially disrupting the child's life. I'm not saying it's impossible, but it can be very hard to do.
Well, that would factor into who gets primary custody, though, these 16.
I'm sorry, what was the question?
These 16 are going to determine who gets primary custody.
Well, if that's what you're arguing over.
Right, well, you just mentioned if you don't have primary custody, it's going to be hard to prove that you should. But
That was just my example. It was just, that's just the example I gave. Like, that's where it usually pops up. It's just that I'm saying that's really hard to do, to go from partial to primary based on parental alienation. It's not impossible.
All right, well, where my head is we're not there yet. We haven't determined who has primary and partial yet.
Yeah, so that we're not there yet.
We're not there yet.
This is just determining what the custody order will look like.
Yeah.
Mm-hmm. The proximity of the residences of the parties, how far you guys live from each other, the party's availability to care for the child or ability to make appropriate child care arrangements. I'm just going through them and then if you guys have questions about them, just let me know, right? The level of conflict between the parties and the willingness and ability of the parties to cooperate with one another. Once again, a party's effort to protect the child from abuse by another party is not evidence of unwillingness or inability to cooperate with that party. The history of drug or alcohol abuse of a party or member of a party's household, the mental and physical condition of a party or member of a party's household, any other relevant factor. All right, number 15, we'll just say mental condition. You telling me mom is crazy is not enough, okay? There needs to be a diagnosis here, okay? There needs to be evidence as far as her mental condition, physical condition as well. History of drug or alcohol abuse of a party or members of a party's household, that has to interfere with the party's ability to care for the child, okay? If one of the parties has the kids and they're drinking when they don't have the kids, the judges are less concerned about that. It's what you're doing when the kids are with you, okay? Obviously, if you're driving drunk with the kids in your car, that's a problem. I will say this, some judges are not as concerned anymore with a little bit of marijuana use. I'm not encouraging it, I'm not telling you, but they don't really care anymore if you're telling me that mom or dad smokes pot once in a while. It just isn't it's just not a big a deal anymore. I'm probably gonna say that, and then you guys are gonna tell me that you brought that up and it cost me your case, and that's just what I've noticed. The level of conflict between the parties. Usually, if you're at a custody trial, the level of conflict is pretty high. It's probably pretty heated. So that's probably not going to weigh in one party's favor or the other, unless you can show that you've been trying to be reasonable this entire time and the other spouse just won't give you any flexibility. Each party's availability to care for the child. You have the right, when you have physical custody of the child, you have the right to have a caregiver for that. You work all day, okay? You work from 9 to 5. You work from 9 to 5, but the kid gets out of school at 3 o'clock. You have the right to have someone watch your kid from 3 to 5, okay? There is something called the right of first refusal, which means if you're going to be away from because what the other party will say is, well, I'm home during those 2 hours. Why can't they just come back to my house while I'm home? So that's a lot of back and forth. And when you have physical custody, you do have the right to have care for your child. That being said, if you're going to be gone, you can agree with the other, or the court can order it. There can be, if you're going to be, say, a certain length of time, if you're going to be away if the kid's going to be in child care for 6 or more hours, 12 or more hours, 24 or more hours, you can give the option to the other parent to have custody during that time. Usually an overnight, if you're going to be away for overnight, you're not bringing the kids, they're going to say, call the other parent first and see if they want the kids, rather than having the kids, stay with the babysitter overnight. Okay. Any other relevant factors. So anything that you don't think that fits into what I just talked about, you can talk about here. So you can literally talk about, as long as it talks about the best interest of the child, you could probably talk about anything in a custody case. Let's see if there's anything else as far as the law goes, and then I'll talk about, okay, cool. Custody is gender neutral. Moms don't automatically get custody. Pennsylvania is very much a 50-50 state in terms of there isn't, no party shall receive preference based upon gender in any award. I know a lot of cases where mom and dad have 50-50 custody. If a parent comes to me and says, well, I'm the mom, I should be getting, primary custody, I'm gonna say you have to have more than that. There's no, it has, unless you're maybe an infant, then you're probably gonna have a little bit more time for obvious reasons. Okay, so let's talk about Chester County, right? In Chester County, custody is 3-tiered. So when you file a divorce, when you file a custody complaint in Chester County, you are going to get a court order or a notice to attend court-ordered mediation. So before you even are allowed in the courthouse doors, you and your the other parent are going to have to go to mediation. You do not bring your attorney to mediation. It's just for the parties, and the mediator it's what it sounds like. They try to mediate an agreement between the parties. A lot of cases are resolved at mediation. The mediator, if the mom and dad reach an agreement at mediation, the mediator will write it up and it can become a court order, okay? If you do not agree at mediation, the next step is conciliation. In Chester, conciliation is a step up from mediation, but below a custody trial. A conciliator in Chester County, in conciliation in Chester County, you bring your attorney, and you essentially present your side to the conciliator, and the other side will do the same. And after hearing all the facts, the custody or the conciliator will make a determination as to what they believe custody will be. If you disagree, you file an appeal. If you are fine with it, you don't file an appeal and it becomes a court order. By filing an appeal and asking for a custody trial, it is what it sounds like. You're going in front of a judge, you're putting on testimony, you're putting on evidence, and you have to show evidence for all of the 16 factors that I just talked about. You can simply say that some of them aren't relevant, but you'll have to say so. And then eventually you'll get a decision from a judge. Yes?
I had heard that there's things such as a master which determines something ahead of time. What is that function?
Conciliator is the same thing as a master.
Oh, okay.
I'm trying to think if there's anything about Chester County that I could. Is there going to be questions while I'm thinking? Yes.
So you know how when you negotiate, you always start high and you meet in the middle, right? Like,
Mhm.
do you advise your clients to go for primary custody in hopes of getting 50-50 custody?
Sure, whatever you ask, it doesn't matter what you ask for in divorce. It doesn't, when you file a custody complaint, it doesn't matter what you ask for. You can ask for primary, it means nothing.
Okay.
Yeah. You're just getting the process started.
And does the mediator work out things like, for example, my 2 kids each got sick last week and this week, and I had to leave work
Yeah.
because he couldn't
Right.
for whatever reason.
Mhm.
So that's what they'll work out in mediation.
What do you want to have worked out? Like what part of
Just
that?
an equal, because I have to work too. I can't just leave work every time my kids get sick if he has 50-50 custody.
Well, who was supposed to have custody that day?
Today was him, and I picked him up.
Well, he has to pick him up.
Okay, so that gets worked out in that legal.
Well, not really. It's not going to say if a child gets sick. I mean, if it's his day, it's his day.
Yeah.
If that makes you, if it's going to say, here's an arrangement in physical custody, 50-50. Every parent has one parent has Monday, Tuesday, one parent has Wednesday, Thursday, they alternate the weekends.
Mhm.
Okay, so you will have 5 days in a row sometimes, okay? If dad has custody on Monday, and that happens to the child on Monday, then they're responsible for the child. That being said, you're going to be okay with him calling his mom to come pick the kids up.
Okay.
Unless you put in the order, a custody order can be as specific or as general as you want it to be. Okay, if you have a problem, if you want to be notified when the kid is sick, if you want to be the one to go pick him up, then you have to specify that in the order. Otherwise, he's going to be able to call his mom to come pick the kid up.
Yeah, we don't have any family in the area.
But, okay, but do you understand what I'm saying? Like, he's going to be responsible for finding a caregiver to pick
Right.
him up, and you're going to be okay with that.
Okay.
If you're, I mean,
That's what I would ultimately like. I don't want to leave work every day to get my kids when they're sick if it's not my day.
right, so if something like that were to keep happening, and I can't see, I mean, this seems like I can't imagine your kids are gonna keep getting sick.
Right,
and
and it's
get
a
fixed, right.
season, yeah.
Right, it's a season, so if he's giving up, that to me is like he's giving up time to you.
Okay. So just document it, right?
I would document
Okay.
everything. Yes, keep a calendar. There's great things to do. A great thing where a lot of my clients print out empty calendar, by empty, it's a blank calendar, okay? And if something notable happens on that, a date, you know, like, I had, like, it was Dad's day, I had to get her, or it was Mom's day, but she gave it to me. Keep a documentation on this calendar, because actually judges like that sort of evidence.
Thanks.
Okay, you know what judges don't like? Let's look at this right now. Pages and pages of text messages between the parties, okay? So you coming and saying, I have a million text messages of us bad-mouthing each other, judge isn't gonna care.
I have a sense that at the lower level here, where you start without a lawyer, maybe it goes to the next level, that I would, maybe you can fill me in on this. I have a sense that there's probably great scope for unsubstantiated assertions.
Sure.
Which a third party, such as the mediator, has no way of proving or disproving or knowing the relevance of, because it's just a very short period of time and it's just a few statements or whatever, and they're not set up for massive proofs. How does the system handle that kind of thing?
You go to the next level. You go to conciliation. A mediation's not gonna, you're right, a mediator's not gonna deal with that. They're there to try to narrow the issues and resolve what they can. If you at least, in order to settle, both parties have to be willing to settle, correct? So if you're coming to mediation flying with accusations and allegations, a mediator's not gonna be able to do much. So I wouldn't put a lot of.
What standard happens at the next level, before you go to court with, let's say, the conciliator?
It's always best interest.
Pardon?
The standard doesn't change, it's best interest of the child.
Well, I mean, in
They're not-
terms
it's
of
not
a lot of
hearing.
loose things that are asserted or may or may not be true.
It's not a hearing, it's not a record hearing. The master, I sometimes bring stuff with me that I wanna show the master, but he can say, I don't wanna see it, or he does wanna see it, it just depends. When you're gonna be looking at proving your claims, you're going to a trial. The only person who's going to listen to that is a judge. You have to keep in mind that they only have an hour or so to deal with you. So they're not set up to deal with something that is gonna require possibly multiple days, which a custody trial can be. Any other questions? I'll stay for a little bit longer. It's only been 30 minutes.